Hello and welcome to the second module of the EU Free Movement Guide. In the previous training module, we said that only legally residing EU citizens may stay beyond 3 months and may apply for permanent residence after 5 years of residence. In this two-part module, we're going to look at the conditions that EU citizens have to fulfill in order to be legally resident. Do you remember what legally resident means? And do you remember which statuses allow someone to reside legally in the host member state? Let's refresh our memory and go over the list of these statuses together. We said that the easiest way to stay beyond 3 months is by being economically active. This means being a worker, a self-employed person, a status retainer, or a job seeker. Being a worker or a self-employed person is the strongest status a mobile EU citizen can have. We therefore need to understand what being a worker or a self-employed person means. We'll look at that later. It is also possible to retain worker or self-employed status when you are not regarded as a worker or a self-employed person anymore. This is possible when your activity was involuntarily interrupted due to unemployment, pregnancy, or incapacity. When this happens, you keep your previous status and are still regarded as legally residing. Job seeker is another status that allows someone to stay in the host member state, but it is a very precarious one, as we will see more in detail later when we discuss the conditions to fulfill to be regarded as a job seeker. Being self-sufficient may also be a useful status, because the conditions needed to be granted this status are not burdensome, but it is only available to people who are able to demonstrate that their own funds are sufficient to support them in the host country. People claiming to be self-sufficient must also demonstrate that they have sickness insurance in the host member state. Students have to satisfy the same conditions by providing a declaration of their resources that are sufficient to support them and sickness insurance. Lastly, we discussed the conditions for being a family member of an EU citizen in the last module. What we can add is that the EU citizen they are related to needs to have one of the statuses we've just listed. Only family members of EU citizens who are legally residing in the host member state have the right to join them there. Now we will start discussing at length the main status that allows someone to be legally residing, the concept of worker. Being regarded as a worker is, for mobile EU citizens, the least burdensome way of fully enjoying residence rights. But whom does the EU regard as a worker? A worker is a person who performs a genuine and effective economic activity, who is remunerated for this activity, who works for and under the direction of someone else, who works for a period of time. These 4 conditions are cumulative, that is to say, all 4 conditions need to be fulfilled in order for that person to be regarded as a worker. The concept of being engaged in genuine and effective activity is problematic and has been used in many cases by member states to reduce the free movement rights of certain categories of workers. It is important to have a clear understanding of what is meant by genuine and effective activity. Any activity that is not marginal or ancillary is regarded as genuine. In principle, part-time work, traineeships, apprenticeships, low-wage work, low hours work, and domestic work should all be regarded as genuine activities. However, in many member states, the authorities take hours and wages to be the main factors to be taken into account in order to assess whether an activity is marginal or ancillary. Before we look at how this concept is applied in different member states, let's see what the EU says. In the Gent case, which is the leading case on working hours and wages as factors for assessing worker status, the Court of Justice of the European Union, the main tribunal deciding on the interpretation and application of EU law, ruled that a cleaner with an employment contract of 5.5 hours per week, providing her with a monthly wage of €175, must be regarded as a worker even if her wages only partially covered the minimum necessary for her subsistence. This shows that even an activity with weekly working hours of 5.5 hours and a monthly salary of €175 is enough for someone to be entitled to worker status according to the EU. Let's look at another case heard by the Court of Justice of the European Union. This time it is about atypical working arrangements. This case is called Trojani. It is about a French national living in Belgium who performed various jobs in a hostel run by a charity for 30 hours a week as part of a community service program, in return for which he received payment in kind, accommodation, and some pocket money. The court ruled that none of the factors, not the special nature of the employment relationship under national law, the level of productivity, the origin of the funds from which the remuneration was paid, or the low remuneration amount, could change whether or not the person was a worker. However, the criteria set by the court for the recognition of worker status have been interpreted and implemented differently, and sometimes inconsistently, in many member states. Many national authorities tend to interpret the genuine and effective nature of the activity narrowly, in order to exclude from residence rights, and consequently from access to welfare benefits, mobile EU citizens employed in low-paid, precarious and atypical jobs. National authorities apply hours or earnings thresholds as a way to define what constitutes work. For instance, in Denmark and Belgium, work below 10 to 12 hours a week is generally regarded as marginal and ancillary. This approach is contrary to the EU case law we have just discussed. EU law does not set any requirements as to the minimum number of hours, the duration of the working relationship, or the level of remuneration required for someone to be regarded as a worker. This narrow interpretation clearly targets mobile EU citizens with precarious working conditions, who are also more vulnerable to homelessness. It is therefore necessary, where possible, to help EU migrants who find themselves in these situations with legal assistance. To this end, it has proven useful for EU migrants to ask for legal advice and to take legal action to challenge negative decisions around residence permits or benefits. Do you remember what we said in the previous training module about the documents required to register after 3 months' presence in the country? We said that workers needed to provide proof of employment, but who decides whether this document is enough for someone to be regarded as a worker? Who are the national authorities deciding whether an activity is marginal or ancillary? Usually, it is local authorities, municipalities in Belgium, who are in charge of the registration of new residents. They often work in cooperation with immigration authorities. These authorities are mainly responsible for checking residence permits after 3 months' presence in the country for temporary residents, or after 5 years for permanent residents. There are also social services and job centres. In some member states, these authorities are responsible for conferring welfare benefits. Given that in principle, only mobile EU citizens who are legally residing are entitled to welfare benefits in the host member state, these authorities may check whether or not a person can be regarded as a worker in order to assess whether or not she or he is entitled to benefits. Let's look at some case studies on this, starting with the UK. These case studies, of course, relate to the time when the UK was still a member of the European Union. The UK uses a minimum earnings threshold test. When public officials have to assess whether or not mobile EU citizens are to be regarded as workers, they check their wage. The threshold has been set at £162, approximately €185 per week. Those who earn more than the threshold are automatically workers. This is the first part of the test, while those earning below the threshold must be able to demonstrate that their activity is not marginal. This is the second part of the test. However, the UK authorities clearly show a tendency to stop at the first part of the test and automatically consider that EU citizens earning below the threshold are not engaged in genuine activity. The imposition of the threshold in practice means that low-wage and part-time workers may be suspected of not carrying out genuine activities. Let's see how the UK authorities have applied this threshold in some case studies. A Portuguese national who had been working as a cleaner for almost 3 years on a contract of 16 hours a week and with an income of £99 per week was denied help with housing costs, a form of welfare benefits, because her income was below the threshold. The authorities considered that she was not to be regarded as a worker because her activity was not genuine or effective. This decision was reversed following legal action, and worker status was recognised. This case shows the typical approach taken by national authorities and how important it is that destitute mobile EU citizens know their rights and take legal action where necessary. Let's look at another case on the application of the threshold that was pursued in court in the UK. A citizen of Sierra Leone applied to remain in the UK as the spouse of a citizen of Ireland residing in the UK. As we discussed in the previous training module, for family members to enjoy residence rights, it is necessary that the mobile EU citizen, the Irish person living in the UK in this case, has a status that grants legal residence there, such as being a worker. In this case, the Irish citizen worked 16 hours a week as a customer service advisor and earned under the threshold. Her spouse from Sierra Leone's application for leave to remain was refused by the immigration authorities because she was not regarded as a worker. However, the Irish citizen challenged the decision before the British courts. The judge rejected the decision of the immigration authorities and concluded that the Irish citizen was engaged in genuine and effective activity and therefore must be regarded as a worker. Let's have a look at another case in the UK, this time not dealing with the earnings threshold, but with short-term jobs. A German national had been working on and off for 2 years as a cleaner in a restaurant. She had had a series of short-term jobs with differing hours worked. She had also had very short periods of being without a job. The immigration authorities considered that each of her short-term jobs was temporary and that each one was therefore marginal and ancillary. She was refused worker status. The decision was challenged in the British courts, and in the end it was decided that she had been a worker over the 2-year period. All these case studies demonstrate that national authorities have a tendency to deny EU citizens worker status, and in doing so are in violation of EU law. However, they also show that when decisions are challenged, they are often reversed. This again demonstrates the importance of legal action to guarantee free movement rights for EU migrants. In Germany, where registration is not compulsory for residents, having worker status is linked to legally residing EU citizens' ability to apply for benefits from the job centre. The number of cases related to worker status in the context of applications for welfare benefits has risen significantly in recent years. Officially, there is no threshold as regards the minimum number of working hours or level of earnings for someone to be regarded as a worker. However, staff guidance published by the German Employment Agency suggests that if someone works less than 8 hours per week, this indicates that the activity is marginal and ancillary. As was the case in the UK, the German courts, where a job centre decision can be challenged, generally complied with the EU notion of worker and corrected the decisions made by job centres. Let's see some real cases in Germany that demonstrate that it is not always easy to understand when an activity should be regarded as genuine and effective. For instance, an activity where the person worked 12 hours in a month, i.e. approximately 3 hours a week, and received a salary of €102 per month, was regarded as not justifying worker status by the higher social court. In that case, the court confirmed the initial decision by the job centre that the activity was marginal and ancillary. In this case, even the upper tribunal involved in the case decided that the mobile EU citizen in question must not be regarded as a worker. A Polish single mother working 8 hours a week for an income of around €300 a month was refused welfare benefits by the job centre on the grounds that she was not a worker and her right to reside was based solely on her status as a job seeker. The German courts, where the initial decision was challenged, confirmed that she did have worker status because the EU notion of worker also covers part-time work, irrespective of the level of earnings or number of working hours. A Romanian national working at least 8 hours a week as a bike courier for €500 gross salary was refused welfare benefits by the job centre that considered that worker status was not proven because of their low working hours and wage. The German courts, where the decision was challenged, considered that the activity must not be regarded as marginal because of the existence of an employment contract and registration with a health insurance provider. When we discussed the registration requirements for EU migrants wishing to stay more than 3 months in the previous training module, we saw that in Belgium, registration with a municipality is compulsory. When someone registers for residence purposes to prove worker status, they must provide an employment contract or a letter of engagement from an employer. In this context, municipalities have reportedly refused to register as workers mobile EU citizens on short-term contracts and those who do atypical work, especially when these generate low wages or involve working part-time. In such cases, the Belgian authorities tend to suggest that these EU migrants register as job seekers, or if possible, as self-sufficient persons. Job seeker is a weak status that only guarantees an unconditional right to reside for 6 months, as we will discuss in more detail later. After 6 months, job seekers must demonstrate that they have a genuine chance of being employed. As regards working hours, it has been reported that in Belgium, when work does not exceed 12 hours a week, this is regarded as evidence of the activity being marginal and ancillary. This 12-hour threshold appears in unpublished guidelines for public authorities. Moreover, Belgian cases suggest that, unlike in the UK or Germany, lodging an appeal before the national courts was in some cases not sufficient to overturn a decision made by the public authorities. An example of this 12-hour requirement can be seen on the City of Brussels website, which gives a list of documents needed to register as a worker. Here it is clearly stated that to register with the municipality as a worker, applicants must produce a 3-month work contract of at least 12 hours a week as a minimum. These requirements are clearly against the notion of worker that exists at EU level. Being a self-employed person is essentially just another way for someone to be regarded as a worker and to enjoy full free movement rights. A self-employed person is someone who works for his or her own business in order to earn a profit. They perform tasks for themselves, not subject to any subordination relationship, in return for remuneration, and carry the economic risk for the business. As is the case for workers, self-employed persons perform an economic activity in return for remuneration. The main difference is that workers, as we discussed before, perform a subordinate activity for and under the supervision of another person. On the contrary, self-employed persons are in charge of their own activity. Therefore, they are not subject to any kind of subordination relationship. In most member states, being self-employed requires that someone create a business and be VAT registered. They are also required to pay taxes and social security contributions. Clearly, mainstream self-employed jobs like lawyers, architects, or skilled workers can easily entitle mobile EU citizens to residence rights, provided that they can demonstrate their activity, for example through business registration, taxes, or social security contributions. For people doing other, more atypical activities, it may be more difficult to prove that they have all the characteristics of self-employed persons. Take sex work, for example. Sex work may be regarded as a provision of services for remuneration, and therefore may fall within the definition of an economic activity. Technically, sex work, if the person works for themselves, may be regarded as self-employed work. But this is only if the activity is considered legal in the country. In some member states, like Germany and the Netherlands, where street, window or club prostitution is regulated, prostitutes may be regarded as self-employed persons, and therefore, in the case of EU migrants, they will have a right to reside if they are able to furnish proof of their activity, for example through bills, clothes receipts, and registration with the police. Another typical example of self-employed persons who are not able to claim residence rights are those doing undeclared work, that is to say, self-employed persons that are not registered with the authorities, as is often the case for EU migrants in the field of construction. Let's take a case study from the UK to illustrate this situation. A Polish national had been living in the UK since 2006 and worked on and off without registering as self-employed, mostly on construction sites. He had serious alcohol addiction problems and was homeless. He then registered as self-employed in January 2014. He started working part-time on a self-employed basis in the construction industry for 16 hours a week and earning £105 a week. Only after registering was he entitled to residence rights and could he apply for welfare benefits. A typical example of homeless people doing self-employed work is that of street newspaper vendors. A case about this activity was heard by a British court in order to understand whether an EU migrant selling a street newspaper should be regarded as an economically active EU citizen as a self-employed person. In one case, a homeless mobile EU citizen who was a street newspaper vendor was regarded by a British court as a self-employed person and therefore entitled to access housing benefit. However, in another case, a different British court considered that the vendor could not establish a right to reside on the basis of being a self-employed person, given the difficulty corroborating the hours worked each week and the very low level of earnings. This ends the first part of the module on the statuses that grant legal residence in the EU. The second and last part of this module discusses the issues of retaining previously obtained status, the conditions for job seekers to enjoy residence rights, and concepts such as actively looking for work, having a genuine chance of finding a job, or who are the economically inactive. We have reached the end of this section. In the next section, we will go into detail about the statuses granting legal residence that allow EU citizens to stay in the host member state beyond 3 months. Thank you for listening.